Today is May 29th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong Motin. Every Thursday morning, Jean Lawler, David Schraga, and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. As you likely know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And every week, one of my favorite parts of the program is when we announce the running total of just how much our generous audiences have contributed in honor of our great speakers since we began the series in 2020. David, would you please do the honors?
It is my singular pleasure, Jeff, to share with the number today. That is $817,195.34. 817,195. Just an extraordinary testament to our speakers, to our attendees, to everyone who participates in Will Work for Food. Thank you so much, everyone.
You're welcome, and thank you, David, for sharing that information with us. Today we have another fabulous speaker, and I'm confident that this presentation will generate lots more contributions for food banks. It is Max H. Bazerman, the author of this terrific book, Negotiation, The Game Has Changed. If you're a fan of this webinar, you probably know very well who Max Bazerman is. But let me just read from the biography paragraph here to make sure that everyone is literally on the same page. Max H. Bazerman is a best-selling author and the Jesse Isidore Strauss Professor of Business Administration at Harvard Business School. His many books include Negotiation Genius with Deepak Malhotra, Negotiating Rationally with Margaret A. Neal, Complicit, How We Enable the Unethical and How to Stop, Princeton, and Blind Spots, Why We Fail to Do What's Right and What to Do About It, with Anne E. ten Brunsell, Princeton. One of the most distinguished speakers we've had, Max Bazerman, please tell us a little bit about the food bank to which you would like people to contribute if they're able to do so, and then on with the presentation. The floor is yours.
Thank you. First of all, it's a delight to be with you, and what a terrific effort that you've created in terms of raising money to feed people. The organization I selected is Share Our Strength, their No Kid Hungry program, created by Billy Shore, who was my freshman roommate at Penn, and left the political advising business in order to go on to have an enormous impact in raising over $1 billion to feed the people most in need. So I'm happy to contribute in this small way to your excellent effort and to do it through the No Kid Hungry program. I'm also delighted to see my friend Michael Singer, who I haven't seen in many years, as he showed up on the screen. So Michael, terrific to be with you and with all of your colleagues as well. So I'm going to go ahead and share my screen if that's okay.
Looks great.
Okay, excellent. So for those of you who might know some of my early work, you might know that I've been sort of at this game for a fairly long period of time. Jeff was just mentioning that he was at the Harvard Law School when Getting to Yes was simply a manuscript in 1980. I was teaching negotiation at the Sloan School at MIT by 1984. And I've taught an awful lot of MBA and executive students since. One common experience that I've had is that people will sometimes come up to me after the class, after the course, and say, this course was a fine course, but, and then you kind of get the long possibilities of what they wish you had done instead. And quite honestly, for a long time, I was of the type of researcher who tended to focus on basic concepts and work out and apply it to any context. And in contrast, there certainly are people who start with the context, whether it's kind of labor relations or insurance claims, and treat that context as very unique and only use the concepts as needed. So I basically saw myself as a more conceptual, basic researcher who enjoyed applying the ideas to lots of other contexts. And you can see this kind of generic ideas perspective in my two earlier books on negotiation, which Jeff was kind enough to mention, Negotiating Rationally with Maggie Neal and Negotiation Genius with Deepak Malhotra. But with a lot of things that have been going on in the world, I find that the context has become more and more important. And that was reflected in sort of the unique things that specific students wanted to learn out of negotiation. That was really the basis for writing the new book. So the new book takes context very, very seriously and focuses on how we can adapt our core negotiation concepts to specific contexts. And the book also has much more contemporary examples. So, just 10 or 15 years ago, the topic that my students were most interested in talking about would be negotiating jobs with the leading consulting firms or venture capital firms. Now the thing to do is to be part of a startup, which creates a whole new set of negotiations that are very different than students just 10 or 15 years ago. But there have been lots of changes that have gone on in the environment that I think have fundamentally changed the way we negotiate, how we prepare for negotiation. Certainly that includes the online economy. It includes changing dynamics about who the most powerful countries are. Sort of COVID-19 was a dramatic experience for many of us, certainly for all of us teachers who might be, let's say, above 50, who had some expectation of finishing our career without ever teaching online. We suddenly found ourselves being regular teachers online on a regular basis. And I think teaching has a lot in common with negotiation in terms of how we need to differentially prepare for online environments versus more standard face-to-face negotiations. Now, when I say that this book focuses more on context, it does without giving up on our core ideas in negotiation. Up here are a bunch of things that I'm sure all of the people on the Zoom are familiar with, and I think that all of them still apply. None of these have gone away with the new context. Thinking about your BATNA from the Getting to Yes book, and thinking about your reservation price, thinking systematically like Howard Rafa has taught us, thinking about the systematic biases that affect negotiation. All of this are important, but we do see some fresh treatments of some topics. And I'm going to briefly talk about sort of anchors and 50-50 splits, because these are topics that have been in the press recently. And then I'm going to go on to talk about how some things I think are in fact quite different than the past. Adam Galinsky and Marie Schweitzer, two fine scholars at Columbia and at Penn, have written a book where they kind of push the idea that even very, very extreme offers have impact, and they mean it in a positive way. And they argue that extreme anchors can pull the agreement in your favor. And I want to question that. Okay, a lot of the people on this call, particularly the mediators, have experience with dealing with people who have very extreme offers. And so there's some notion that your first offer should be just this side of crazy as opposed to that side of crazy. And I think that that's a problematic conclusion. And I think it comes out of people occasionally getting an amazing story where they get an extraordinary deal. But I think the more common effect is that that extreme offers end up destroying negotiations, increasing litigation costs, increasing the likelihood that we actually end up in court, as opposed to having a constructive negotiation. I'm a much bigger believer that anchors, that favorable anchors certainly might matter, but they're going to have the greatest impact when they occur within the zone of possible agreement. So that's one topic that I go into at length. Another topic is the role of 50-50 splits in negotiation. I focus on this. I even spent a whole chapter on this because Chris Voss, who's a very popular negotiation author, basically has a book called Never Split the Difference, which I think is about the worst book title I could imagine, but it seems to have worked in the marketplace. But the notion that we should never split the difference strikes me as a little bit strange. I think that there's lots of times where what we're arguing about isn't worth the time that we could spend disputing, and splitting the difference ends up being a fine way forward. In contrast, Barry Nelbuff has a book called Split the Pie, which argues for identifying what the bargaining zone actually looks like, and then going through life splitting the pie equally between disputants. And I think that's pretty good advice, although I'm not sure I'm ready to use that advice the next time I buy a new car. So I'm kind of not with that level of extremity either. And I think back to my former colleague, Dave Messick. He was my colleague at Northwestern and has passed away since he wrote this work. But he argues in a very interesting way that 50-50 splits are not necessarily fair. Rather, they're what we use as a social heuristic, so we don't have to discuss what would be fair. So if I happen to go to dinner with Michael Lewis, my friend who I haven't seen for too long of a time, but I'm not very hungry and I just have an appetizer, but Michael has everything, including multiple drinks. And at the end, the waiter comes along and one of us says, well, we'll just split the bill. It's not because it's fair. After all, I just told you, Michael had lots more food than I did, but rather the 50-50 split is a social heuristic, so we don't even have to discuss who ate how much. So the discussion is unpleasant, and when you're with somebody who you have a positive relationship with, splitting the difference can just be a very easy way to move forward. So I disagree with Nelbuff a little bit, and I disagree with Voss a lot. And I think it's very useful to think about why it is that we have this sort of rule of thumb to split things 50-50. Okay, so one thing I want to talk about is ethics. And I spend a fair amount of time in the new book talking about ethics. And on the screen, you'll see a problem where people basically think that they're getting bad advice from their friend who is a real estate agent who has different incentives than they do. And the question is, how should I think about the fact that this agent is giving me biased advice in the direction that they prefer? Should I even remain friends with somebody whose advice would benefit her, but not necessarily us? This person concludes your question with. And my reaction is, one of the things that we need to understand about ethics is that it's not as cut and dry as strict legal definitions of the word lie might imply. Rather, we often have people who have views that are different than our own, where they honestly believe what they say. So I think of the famous Linda Babcock and George Lowenstein simulation of a negotiation between a plaintiff and a defendant over how much they should agree to on an accident case where a car has hit a motorcycle. And what they find is when they create an incentive compatible way to find out what does each party think that the case is worth, that plaintiffs honestly believe that the case is worth more than the defendant. So it's not that they're just exaggerating for the purpose of effective negotiation, but they honestly have different views. And I think that one of the things that we need to understand about ethics is that perfectly good human beings might make statements that the other side finds objectionable or unethical, while actually having some belief in exactly what they're stating. Okay, now I want to talk a little bit about perhaps the biggest contextual change that is affecting negotiators over the last couple of decades. And it's illustrated by the fact that I'm talking to you over Zoom rather than us needing to gather in New York City for us all to meet, incurring lots of costs. All of a sudden, we often go to seminars on Zoom and I'm not picking Zoom over Teams or Google Meets or whatever platform you like. I'm comparing the notion of online meetings versus face-to-face meetings. And they're fundamentally different in lots of ways. When in the year 2020, when I was forced to be a Zoom teacher, I hated it for about a month, and then I got used to it, and I love Zoom teaching, and I love Zoom presenting. I really appreciate the fact that we didn't have to travel in order to get here, and that we're able to meet so efficiently. But we also find that lots of people are negotiating through other mechanisms other than traveling to see the person face to face, whether that be Zoom, emails, telephone conversations. And I find it striking to think that just, if we go back to 1990, how different it was to book a hotel room or to negotiate the price of a hotel room in comparison to the way the world works now. And some of the things that I think we need to think about is the nature of the communication. Terry Kurtzberg, a professor at Rutgers, has done lots of interesting work on the specific details of how you conduct your Zoom negotiations and how it affects negotiation. So we know certain things like that there may be tactics that you can use on Zoom, but the less context-rich the environment, and I'm saying that email is not very context-rich, telephone is a little bit more, Zoom is a little bit more, but none of these are as context-rich as meeting face-to-face. It makes it more difficult to create value, to find creative ways to bridge the gap. So one of the things that mediators need to be even more skilled at is finding out the underlying interests when we're dealing in a Zoom environment rather than a face-to-face environment. Again, there's a chapter in my book on how negotiation is different in the online world, and I reference Terry Kurtzberg's research a fair amount in that environment. Okay, now, so the book is called Negotiation, the Game Has Changed. There's also significant discussion in the book about sort of changing the game. And a few of you might know that, in fact, I've run an executive program at the Harvard Business School for 25 years now with close to 5,000 participants. And the program is called Changing the Game. And I want to give some examples that I do cover in the book about how we can change the game. So rather than just negotiating the game in front of us, how we might make strategic moves to change the game. So the following story is true. On a Friday night, it's now maybe half a dozen years ago. At the time, the negotiation condo market was hot. This is before COVID, and basically, I was contacted by a colleague who had her condo up for sale. And it was in the Cambridgeport area, for those of you who have come through the Cambridge area. And the realtor had convinced my colleague that she was well off to underprice the condo in order to create a bidding war. And I think she thought that the condo was worth between $1 and $1.1 million and put the condo on the market for $989,000. But what created the call to me was the fact that she had just received an offer. Okay, now the offer comes in after the realtor and the seller had agreed that they weren't going to sell before a stated day the following week, and that they were going to wait to get competitive offers. But they happened to get an offer at 1.125, which seemed very attractive. Okay, the only problem was it exploded before the open houses would finish over the weekend. And the question was what to do. So they clearly had a strategy of trying to create an auction, but they got a very attractive offer. And the question is how to respond to this. And a suggestion that I made was based on having spent time with my colleague Guhan Subramanian, who has spent time working in the merger world. And in the merger world, there's a concept called Go Shop. And the way Go Shop works is that basically you agree with the buyer that you can continue to market. They will keep their offer valid. And if you can get a better offer, you'll give them the chance to beat the offer that you go obtain. So what the buyer gets in return for letting you go shop is the knowledge that they can always beat the best offer you find and take away the deal. And I proposed this strategy to my colleague, who basically implemented the strategy and continued to market the house, eventually getting a $1.2 million offer, which the original buyer increased by the $10,000 that they had provided in this Go Shop agreement. And this allowed my friend, the seller, to both find out what the market would bear, but provided the buyer with the knowledge that, in fact, if they so chose, they could, in fact, guarantee that they would be able to obtain this condo in a competitive market. So this is one way to basically change the game. So I also want to tell you about my negotiations of a couple of books, because it's kind of fun. So when I was negotiating my contract for Complicit, I ran what Guhan would call a negotiation, which is somewhere between an auction and a negotiation. So I started in an auction format, but as it proceeded, I basically told one publisher, Princeton, that the auction seems to be moving along fine, but for a variety of reasons, I'd like to sign with you. Will you, in fact, increase the advance by 20% higher than my prior bid? And I gave them a chance to take it, which I opted to do. So basically, I changed the roles in the middle of the process from auction to negotiation, which I understand I was legally allowed to do, and that changed the process. But this is kind of intriguing. So after Complicit was published, it was time to negotiate the contract for the current book, Negotiation. And for reasons that I don't know, I'll attribute it to being overly busy. I ran into the fact that the following clause existed in the bottom half of the slide in the contract. Now, I almost always strike out these clauses that give the current publisher first option on the next book. But for reasons that I can't even recall, I didn't get around to striking this out. Perhaps this is one more example of people actually do need a lawyer more than they think. And with this, when I realized that this was in place, basically it was time to go talk to Princeton about the next book. And I was assuming that, I would follow the legality of what was in the contract, but I would negotiate in good faith, not reach an agreement, and then go out for auction. In fact, Princeton effectively did lock up this book. They made me a very attractive offer, which I signed. So in many ways, I changed the game on the Complicit contract, but I was intrigued to see how Princeton changed the game on the next book as it developed. So some intriguing ideas about how to change the game. Finally, since I know we have a lot of mediators who attend this session, and I also assume that a lot of business comes from the insurance industry. And it's an industry that I've done a fair amount of work in, trying to create more effective and more reasonable negotiation practices. I want to introduce the idea of a final offer arbitration challenge. Now, I realize some of you have heard of final offer arbitration before, so I'm going to quickly describe the idea and then talk about how to turn it into a challenge, focusing on what I often hear as a very difficult problem, of how to get unreasonable people to be reasonable. And I'm going to suggest that this can be used by negotiators or by mediators when confronted with unreasonable negotiators. So a little bit of history. 1966, Carl Stevens, a labor relations expert, first proposes final offer arbitration. It says baseball on the screen because that's the most famous use, which I'll get to in a minute. But Carl Stevens is basically writing about labor relations more broadly. And the basis for creating final offer arbitration was the notion that as negotiators would prepare for arbitration, there was a perception, real or not, that too many arbitrators simply split the difference. And if an arbitrator is going to split the difference, you want to be as extreme as possible in order to make that midpoint favorable to your side. And what Stevens proposed was creating a new arbitration process whereby the two sides put an offer in an envelope, the two envelopes come in, and then the arbitrator has to take one side or the other, not a compromise. And that meant that an arbitrator might have to pick between two unreasonable offers and pick the least unreasonable of the two. But Stevens highlighted as he was developing this idea that the benefit of final offer arbitration is that it will be scary enough that people who are facing final offer arbitration will come together by being more reasonable rather than risk what could happen under a final offer arbitration procedure. And that's exactly the experience that we see in baseball, where they use final offer arbitration. A lot of player team negotiations file for the use of final offer arbitration, but very few arbitrations are heard. Rather, as the arbitration approaches, the players and the team settle. And even when they do go to arbitration, both sides wanting to win the arbitration become increasingly reasonable, and the two offers are often not very far apart as a result. So one of the things that baseball arbitration does is it brings parties together. So I was working with an insurance company on a long consulting project with Danny Kahneman, who unfortunately recently has passed away. And we invented what we call the final offer arbitration challenge, obviously borrowing the core idea from Stevens' work. And the idea here is that Stevens is envisioning a system like baseball, where the institution says under X, Y, and Z circumstances, you go to final offer arbitration. What we were responding to was we heard lots of insurance executives talk about the unreasonable plaintiff attorneys that they ran into. Okay, the plaintiff attorneys who are demanding 10 times what the claim is worth. And what we suggested is that if they really believe that they're being reasonable and the other side isn't, what they should do is propose taking the specific case to final offer arbitration, where the notion is both sides will submit a final envelope to the arbitrator will then pick one side or the other. And the idea here was that in most cases, the unreasonable plaintiff's attorney may not say yes to go into final offer arbitration, but your willingness to go to final offer arbitration will lead them to come back to the bargaining table with a much more reasonable number. And at least in this insurance company, this was frequently used on some of the most difficult cases. I don't have personal experience seeing this used by mediators, but you can certainly imagine if a mediator is faced with two parties who aren't moving sufficiently, and one or both are being unreasonable, proposing final offer arbitration may be a particularly nice way not to get the claim resolved by an arbitrator, but actually bringing the parties back together in a more reasonable way. So those are some ideas, some thoughts, some things that you may have heard of before or perhaps not. Here is the book, Negotiation of the Game has Changed. And if you are interested in buying it and you go to the Princeton site, BAZ30 will also get you 30% off the price of your book. So with that, I'm going to stop and see if there's see what the group would like to talk about.
Max, that was terrific, stimulating and educational. Thank you very much. I have a few questions I'd like to take up with you. One is you talk about extreme opening demands and trying to make a demand that is within the zone of possible agreement. My experience as a mediator is that at the beginning of the mediation, there is no zone of possible agreement. It's not some pre-existing thing that's out there that we just need to discover with a better map. Rather, it's something that we need to invent anew as we go through the process of conversation and negotiation in the mediation. So what is your sense when the mission is to try to invent a zone of possible agreement? And sometimes we struggle all day to get people not to a zone, but just barely to touch at one point of possible agreement. What is your advice for opening offers and demands in those sorts of circumstances?
Sure. So first of all, I'm going to work from the back of your comment toward the front. So I certainly agree with you. If we listen to a negotiation, we hear this discussion that comes to a point. And I would argue that that those parties think that they found the agreement. It's not like they found some point within the zone. They feel like they found the only agreement. What's striking to me, Jeff, about that is when I teach simulations to MBA students or to executive students, and I know what their reservation price is, and that there's a pretty big zone of possible agreement, and we see it by the variation of the 50 different pairs in the room coming back with 50 very, very different agreements. Most of the parties who reached some point have no idea that that zone exists. So the question is, did that zone exist? Or was there only a point in their particular case? And my reaction from an analytic tradition is that the zone existed, okay? But there's a perception that they found the one point. And what I mean by that is that we have many situations in which there's a range that the parties both prefer over what they would get if they truly impassed and had to go to court, okay? But based on our negotiation skills, we might end up at 1.2 million or 1.5 million or 1.8 million. So the zone could exist. That doesn't mean that it's apparent if we listen to the conversation. So I think that the mediator wants to understand what are the alternatives that the parties face? What would be the implications of continuing with legal action? How that might help you inform both sides about how to think more systematically about sort of what the lowest that the plaintiff might take and what's the most that the defendant might pay. And for the mediator to realize that there probably is, in fact, a zone rather than a point that you're trying to find, even though the conversation will continue to feel like we're moving and moving, trying to find that point that will work. So I would argue that a zone, a wider zone of possible agreement often exists, even when the transcript of the dialogue would not reveal that to us.
Okay, so assuming that a zone of possible agreement always exists with some range or other, many mediations end with the so-called double-blind mediator's proposal, where there seems to be an impasse and the mediator makes the proposal. Each side says either yes or no. The mediator simply announces deal or no deal, so that if you have said no, you in essence never find out whether the other side has said yes or no. Your generosity cannot be exploited, just to define the term. So
Thank
if
you.
there's a zone of possible agreement and the mediator is called upon or requested to make or has his or her own idea to make a mediator's proposal, how can we as mediators prevent our own biases from infecting that mediator's proposal, assuming there's a zone and it could go more towards one side or more towards the other?
Sure. So I think that a I love the Rawlsian term veil of ignorance. And I think that a mediator can approach a veil of ignorance. If you weren't on the plaintiff side, if you weren't on the defendant side, if you weren't on the buyer side, if you weren't on the seller side, what would be fair? I think that that's actually what we're trying to find. I think a lot of mediators, in fact, want to get a deal done. I think that it's the job of the mediator to get a fair deal done. And I think that that comes from a lot of the same basic homework that we encourage negotiators to do, to think long and hard about what is their their best alternative to a negotiated agreement, to identify what's going to actually happen if there is no deal. So I would argue, take any legal dispute where the parties can settle now, or they could incur legal expenses, delay, end up in court, further damage the relationship, and eventually get a judge or jury decision. There was a bargaining zone because they could have had the same deal without those costs. So they could have improved over the decision that they're going to get under that legal process. And I think it's a mediator's job to help both sides be more reasoned negotiators. And if they're more reasoned negotiators, that's going to help open up that zone of possible agreement in most cases, certainly not all cases.
So let's say the plaintiff has stalled out. They're demanding $1 million and they just won't budge. And
Yep.
the defendant, the insurance company, they've stalled out. They're offering $800,000. They just won't budge. Does a mediator just split the difference? Does a mediator just say, well, in my omniscient, divinely inspired view, I think the right number is 950 or 825? What should a mediator do in that circumstance?
Yeah, I think that the strength of mediators, certainly moving forward, has to be in their ability to help both sides reason more about what their best alternative to a negotiated agreement looks like, and therefore what the wisest course of action should look like. To the extent that mediators were going to simply split the difference, well, that just isn't a very sophisticated task, and we don't need people with a detailed understanding of how to negotiate effectively to do that. In fact, if it was simply to identify what a fair number would be, I think that the mediator is going to lose business over time as well, because an AI program can analyze the case as well and propose that number to the two parties in using the same double-blind process that you're suggesting the mediators often use in the current face-to-face environment. So mediators need some other strength, which I think that they have, and that is their ability to communicate with the parties, to help the parties reason as a wise negotiator should. Because if we have two wise negotiators, they're going to want an agreement within the zone of possible agreement over the same outcome that they would get out of an extended costly legal process.
So does that mitigate against mediators making mediators proposals at all and simply encouraging the parties to continue your negotiation, maximize self-determination, and let's work it out that way?
Yeah, no, I think that the case you gave, they're at 800,000 and $1 million. I think you want to use more traditional tactics to try to get them to an agreement. But if you're stuck on those numbers, asking the parties, would they like you to go off and assess what you actually think is fair and what a good estimate would be of what the settlement would be in a courtroom. If they both say yes, I think it's great to do that, but I don't think that you want to come back. I would specifically say that the number that would make them most suspicious of your behavior is to come back at 900,000. Like, what were you doing with your sophisticated knowledge? I think it makes sense for you to actually go figure out what the fair number is between 800 and a million, rather than to simply split the difference. So I think that that's a good toll. Now, if we were at 800,000 and 10 million, that's when I think something very different may make much more sense, like the final offer arbitration challenge, because we need to get some significant movement away from the parties.
Now, most mediators, in my experience, when they make a mediator's proposal, will disclaim fairness, but rather emphasize practicality and say this is the number to which I think both of you would agree, perhaps in a grumbling fashion, but yet you would agree. And yet when people hear the mediator's proposal number, for example, when the representatives of the insurance company have to call the home office and say, boss, mediator's proposal is X, the proposal is presented up the food chain with as if it's imbued with some divine notion of fairness. Any thoughts on that?
Yeah, I want mediators to certainly take fairness into consideration on the number that they pick. I think this notion of a number that we can live with too easily leads to the $900,000 number in the story that you told. And it may provide some political cover for both parties to settle, and that may have some value. But I think that that a well-reasoned explanation for why you're proposing 865 or 935, I think, is much more compelling than something that looks like something that anybody could have come up with simply by dividing those two numbers.
And then when the mediator makes the mediator's proposal, tells the plaintiff and the plaintiff's counsel, for example, and then leaves the room, and the plaintiff turns to his or her lawyer and says, well, that's an interesting number, but how do we know that we couldn't do better if we were just continuing in the negotiation to hash it out? What's the right way for a lawyer to deal with that potential criticism?
Yeah, well, so we don't know that you wouldn't do better by continuing to negotiate and hammer it out. But based on my experience as a mediator, what I can tell you is that you're going to incur significant legal expenses as you continue to pursue your strategy. As an insurance company, you're putting the reputation of your firm at risk by not putting a reasonable number on the table. I think that this number, taking into consideration the cost of litigation, is better for you than the expected value of what you're going to get hammering it out. But can I guarantee that you couldn't do better by hammering it out? Absolutely not. I can simply say that it's a pretty good decision based on our current state of knowledge.
So how does that square? And this is a personally troubling thing to me. How does this square with a lawyer's ethical responsibility, not just to get a pretty good deal for a client, but to get the best deal possible for the client?
I think that it's the best deal on an expected value basis. We can never, I mean, to the extent that you fight forever, that might increase the likelihood that you get that 1.1 when we're haggling between 800 and 1 million. But what you're most likely to get is some number between 800 and 1 million after you incur $300,000 or $400,000 of legal expenses as we go through the court system and the appeals process. So if we're constantly trying to get the best deal we could possibly imagine, rather than a good deal while minimizing costs. We're going to be using the court system far too much, creating a variety of societal problems and not serving the interests of our client either.
Now, Max, let's change topics a little and let's talk honestly about the subject of lying,
Yeah,
because there is very interesting treatment in this book, and I really enjoyed reading the portions on lying and when, if ever, you should lie in a negotiation. And you seem to say that there are some life and death, world-saving circumstances where maybe lying is okay. Can you elaborate on that? I found your discussion of it fascinating.
yeah. Yeah, so I don't think I would use those words as my summary. But what I do say in the book is that in the Cuban Missile Crisis, the Kennedys lied to the American public. And the situation that they were in was they basically reached an agreement with the Soviet Union to get the missiles out of Cuba, which were an existential threat. And in return, they basically promised to take the missiles out of Turkey that were aimed at the Soviet Union. And it would have been politically unacceptable for the Kennedys to have admitted that. And so they lied to the public about that. And my reaction is that was a lie that may have well saved us from nuclear holocaust. And my reaction is if you can tell a relatively small, unimportant lie that saves us from nuclear disaster, that seems like a good trade-off. So that then becomes sort of, why don't I recommend lying more regularly? And my rationale is much more, for those of you who took Philosophy 101, my rationale is much more utilitarian than deontological. So deontologists are going to suggest we should never lie. That's just the way to go through life. But obviously, I don't agree with that, given the example I just gave from 1962. On the other hand, I very much believe that we create far more damage by lying in negotiation than benefit. So my reasoning for encouraging my students not to lie isn't due to some logic that's consistent with why their mother told them not to lie when they were 6, but because they're going to create far more damage to themselves than they realize, that reputations last longer, lies come back to haunt us, and most liars aren't even aren't very effective liars to begin with. So I want to appeal to people based on the notion that lying is not a very effective strategy. Rather than because for any kind of religious or moralistic reason, I want to sort of appeal to the logic of how lying is going to affect them. So it's for that reason that I think, once every 50 years, I think that there's a good reason for somebody to tell a lie. That doesn't translate into the fact that I think it's okay for you to occasionally lie in negotiation. That's not my statement at all.
So, Max, the example that you gave of the Kennedys lying to the American people is
Yep.
not the same thing as if the Kennedys had lied to the Russians, the actual negotiation partner. So the
Okay.
concept, how does the concept that, well, perhaps it was okay for the Kennedys to lie to the American people, does that ever transport over to when you're actually dealing with your negotiation partner?
Perhaps. So I'm not going to endorse the following lies, but I think that you'll see some of their appeal. You look nice tonight is a lie that many of us have told, or we've told the person that we sold something to, you got the best price you were ever going to get out of me. These may be lies that create approximately no harm and have some benefit. So while, in fact, I don't go out of my way to tell what many people call white lies, I also don't have any need to condemn them. If they're going to create more good for the world than harm, I can remain agnostic and not be part of that discussion.
So it raised in my mind a question of the problem with telling little lies. And I was inspired by what I read in this book, Blind Spots, which you also wrote, talking about ethical fading and how in the minds of so many people, you get used to telling a little lie, and then all of a sudden you can tell a little bigger lie, and all of a sudden you're just a corrupt person. How do we protect ourselves against that kind of ethical fading, which you spend so much time in Blind Spots warning against?
Yeah, so first of all, I want to credit my co-author of Blind Spots, Ann Tenbrunsel, who's a professor at Notre Dame, for the term ethical fading, which I think is just a terrific term. So I'm not hiding from it. I just don't want to grab intellectual credit for what my co-author deserves credit for. And the basic notion of ethical fading is when we're in the midst of so many other tasks in life, it's easy to let our moral selves lapse at least a little bit, okay? And the ethical aspect of the problem seems to fade from existence. So when someone has told a lie or deceived in some way, and you ask, why did you do that? Well, they often have a perfectly good business rationale for what they were thinking about. A good example is the literature on goal setting. We all know that goal setting can be effective in driving performance. We also know that goals can drive people to behave in unethical ways in order to reach those goals. And as we're striving to reach the goal, which my boss set, or by which I lose my job if I don't meet that goal, or I don't get the bonus if I don't reach that goal. Ethics seem to fade in the context of pursuing those goals. So I think that awareness is a critical issue, and I think that we want to think about what kinds of behaviors we want to engage in. And I think most of us would hold ourselves to a higher standard than the behaviors that we might actually follow, because ethics so commonly fade at the moment of decision. So we also imagine in Blind Spots that you could have a person who is perfectly ethical with their intentions. At the moment of decision, their ethics fade and they engage in some bad behavior. And we could think of lots of different organizations that have been in the press over the behavior of lots of their employees engaging in bad behavior. And then in retrospect, we will look back and wish we had behaved more ethically. So we often think about who we would like to be in terms of sort of our should self. We look back at our behavior and wish we behaved as our should self would tell us to do. But in the moment of decision, we're affected by ethical fading, and we do what our kind of greedy oneself may want us to do. So I think we can do better with more reflection.
Thank you. Okay, we have a couple of minutes left. If anybody else would like to pose a question, just unmute yourself, please, and ask away.
I have a question. Max, what do you think about the use of formal risk analysis or expected value calculations as a mediator or negotiator? And to use your term, is that a social heuristic for fairness that parties can use given the uncertainty of the exercise?
Yeah, so earlier we talked about Roger Fisher and getting to yes, and in passing I mentioned Howard Rafa, who is of the same era as Roger Fisher, kind of a generation before my time, although I knew both of them. And Howard Rafa wrote a terrific book called The Art and Science of Negotiation in 1982, which is very much of a decision analytic approach to negotiation. And whether you want to use the language of decision analysis or not, I think a good mediator will have done some decision analysis behind the scenes to help identify what's fair. So, Jeff earlier talked about a lawyer has an obligation to get the best deal for their client that they possibly can. Well, I think that should be thought of in terms of an expected value. We can't ever know that agreeing now rather than pushing for more is the best deal I possibly can get. But it may well be the case that a wise decision is to take the offer on the table rather than continue litigating into the future. But in simple form, I think that decision analysis has an important place in helping anybody think clearly and precisely in terms of the right negotiation strategy moving forward.
Thank you, Peter.
It's a big topic, Max, but going back to the beginning of your presentation, any parting thoughts for us on how to train the younger generation that's coming up today in the new digital age where they are potentially
Yeah.
less prone to face-to-face conversations, more likely to send text messages and emails?
Yeah.
How do they move towards success in these dynamics using, the cultural realities they're dealing with?
Yeah, absolutely. A terrific question. So first of all, for those of us on this call who teach negotiation, we have the enormous benefit that people love to learn how to negotiate more effectively. It's, one of the secrets, don't tell anyone else, but negotiation is about the easiest thing in the world to teach because people are so enthusiastic about learning the material. I think that we need to adapt our educational strategies moving forward to meet them where they are. And this might mean conducting more negotiations over Zoom and sort of highlighting what are good negotiation practices over Zoom. I think that we're all being confronted with what do we do in an educational environment where our students can literally take our simulation materials, put them through ChatGPT, and ask what would be a wise negotiation strategy moving forward. And you can either say that's cheating, or you could say that's actually teaching negotiation in the future world that we're facing. So our students are very prone to defend the use of AI because that's part of how they go through life. And when they get their position in their consulting firm, they're going to be using AI as well. So I think that these are all challenges that we need to face. And I think that the context matters, which is a kind of a core argument of the book, and we need to adapt to the new environment. And as a 69-year-old, I find myself spending a lot of my time thinking about how do I adapt my teaching to the current context that we're all facing. So let me just thank you for the question, David. Thank you, Jeff, for organizing us. And I appreciate everybody who's on the call taking the time to be with us today.
Max, thank you so much. This was a tremendous presentation, very educational. You were candid and comprehensive, and I think everybody benefited a lot. I know I did. And I know that I will be motivated, and I hope many other people will be motivated to contribute to No Kid Hungry in your honor. And I hope that people go to the Princeton Press and use the discount code for negotiation. The game has changed. And while they're at it, they might also pick up Blind Spots, which is also an excellent book. And while they're at it, they might pick up Negotiation Genius, which is another excellent book that you have written, co-authored, Max, and from which I've learned a lot from your writing over the years, in addition to what you offered us today. Thank you very much. And with that, we are complete.